Good afternoon. My name is Reagan Smith, General Counsel of the Copyright Office. This is now day 3 of our Section 1201 hearings, and this is on Class 7, which concerns a proposed exemption to permit text and data mining for literary works and motion pictures. I think many have participated or perhaps watched before, but just to clarify, someone from the government will be calling on panelists to answer specific questions. I think we anticipate today's discussion will cover a number of topics, so we're asking that you please try to stick to the question presented and limit your response to a minute or so. If you wish to speak, we found it works a little bit best if you can use the hand raise button in Zoom, but if you're having technical difficulties with that or otherwise wish to contribute, you can just sort of wave your hand in real time. Anyone either watching or participating can indicate in the Q&A or the chat if they're having technical difficulties, and someone from the Copyright Office will reach out to assist them. The last thing I would like to remind everyone in terms of rules on the road is that anyone who's watching who wishes to contribute to tomorrow's audience participation session, which will allow presentation on any of the topics in the rulemaking, you can sign up in the SurveyMonkey link, which has been circulated in the chat. And I guess the very last warning should be please mute your audio when you are not speaking. So we'll start by introducing ourselves. So from the Copyright Office, if we could have Mr. Amer, Ms. Rubel, Ms. Chauvet, and Mr. Welkowitz introduce themselves.
Hello, Kevin Amer, Deputy General Counsel.
Jordana Rubel, Assistant General Counsel.
Hi. Good afternoon, Anna Chauvet, Associate General Counsel.
David Welkowitz, Attorney Advisor.
Thank you. And from NTIA, Mr. Zambrano Ramos.
Hi, everyone. This is Luis Zambrano Ramos. I'm a policy analyst in NTIA's Office of Policy Analysis and Development.
Okay, I see Mr. Moore has joined us. We are introducing ourselves, Mr. Moore. So welcome. We're glad the technical issue was resolved. We'll start by asking those who are here testifying in support of the exemption to introduce themselves. And I know Ms. Schofield was unable to attend today, but if we could start with the UC Berkeley folks. So I have Dr. Beman, Dr. Hoffman, Mr. Stallman, as well as I think some student attorneys.
Hi, I'm David Beman. I'm Assistant Professor in the School of Information at UC Berkeley.
Good morning, I'm Chris Hoffman. I'm Associate Director of Research IT at UC Berkeley and Program Director for Research Data Management.
Eric Stallman, I'm the Associate Director of the Samuelson Law Technology and Public Policy Clinic.
Ziad Al-Ghamdi. I'm a clinical student at the Samuelson Clinic at UC Berkeley.
My name is Tate Anderson. I am a law student with the Samuelson Clinic as well.
My name is Erin Moore. I'm a clinical student with the Samuelson Clinic.
Thank you. Mr. Band?
Hi, I'm Jonathan Band. I represent the Library Copyright Alliance.
Thank you. Dr. Wormer-Coulon?
Hi, I'm Alex Mercolin. I'm a digital scholarship coordinator at Temple University Libraries.
Thank you. And then I think we'll go alphabetically for those who are testifying not in support of the exemption. So Mr. Ayers.
Thank you. Hello, I'm Michael Ayers, and I'm representing the Advanced Access Content System Licensing Administrator, LLC, commonly known as AACSLA, and DVD Copy Control Association, usually referred to as DVD-CCA.
Thank you. Ms. Charlesworth?
Hi, I'm Jacqueline Charlesworth. I'm representing the Association of American Publishers.
Mr. Moore?
Chris Moore, General Counsel, SIA.
Do you have Mr. Taylor? Yes.
It's David Taylor. I'm counsel to AACSLA DVD CCA, which Mr. Ayers had explained earlier what they represent. Thank you.
Thank you. And Mr. Williams?
Good afternoon, Matthew Williams from Mitchell, Silberberg, and Knupp, representing the joint creators and copyright owners.
Great. So we'll dive in, and one of the things I wanted to just start with, I think there's a lot of broad comments both in support of and opposing this exemption at all, which we will certainly get into. But one of the things that has common with this session, as well as the one we had earlier, is that in the reply comments, there were a number of refinements offered by those in favor of an exemption. So I wanted to make sure we have an accurate understanding of the sort of proposal on the table, as well as allow the those who oppose an exemption to clarify if that is in fact their understanding too. So what I have is that the proposed exemption initially would have allowed researchers to engage in circumvention in order to deploy text and data mining techniques on literary works and motion pictures. And it has been refined by who the user is to specify that it should be a researcher affiliated with an institution of higher education, and there's a specific definition offered by that for the purpose of scholarly research and teaching. There has been another refinement offered that the researcher should use reasonable security measures to limit access to the corpus of circumvented works only to those other researchers for purposes of collaboration or replication and verification of research findings. Works which are accessed only as a rental would be excluded, although I think there's some concern that the exemption would not require the works to be owned outright with respect to digital copies. The fourth sort of broad, I guess, statement we saw in the replies is we're not quite sure whether this exemption is being requested to encompass consumptive uses, such as quotations, or whether that is not necessary or perhaps covered by a separate exemptions that already exist. And then the fifth thing I will note is for literary works and motion pictures specifically, there has been some exclusions. So computer programs or compilations compiled specifically for TDM, is no longer what is being sought, as well as the AACS2 technology or motion pictures offered for streaming only. So does anyone who is in support of the exemption want to say what I have gotten wrong or perhaps overlooked in terms of what refinements were made in the reply stage? Or let me know if I got it right. Mr. Stallman?
Yeah, and thank you. I would say for the most part that you have it right. There are a few points of clarification that I did want to make. One is to make sure that when we're talking about the institutions in question, this includes colleges and universities, nonprofit colleges and universities, as well as library, archives, and museums. And then with respect to consumptive uses, yes, our intent is not to include those. We think that those are covered by different exemptions, or in some cases, particularly with respect to literary works, the exemption is not required for those uses. I would say that those are the major points of clarification.
Okay, thank you. Does anyone who has filed a comment in opposition wish to say, do any of these refinements address some of the concerns? And again, I appreciate we've also seen there's concerns to whether there should be an exemption at all, and we will definitely tee up those issues too. But we wanted to give the opponents an opportunity to respond to the reply, since it did iterate pretty significantly. Ms. Charlesworth?
Yes, well, first of all, thank you. And I think, I think that they certainly narrow what is an extraordinarily broad proposal. Speaking on behalf of the book publishers, though, they really don't go far enough, because the proposal is still very broad, would allow, researchers to amass very large libraries of material, unprotected material. I can go through some of the specific concerns that remain. I mean, there's no real definition of TDM. I think I'm still confused about the consumptive use issue, because, if you're counting words or how often a word appears in a book, that's one thing. But what I keep hearing and what I read is just that you could use the expressive content, which would, by the way, be offered in full text format to researchers, which is quite distinct from, and I know we're not talking about the case law yet, but that's quite distinct from any recognized fair use under US law. So, you know, I think there's still a lot of confusion really about what activities would be covered. And from reading the papers, you know, the submissions, it looks like it would be pretty much anything that involved sort of an interaction of at least speaking for the book community, you know, a literary work with a computer where there's some sort of computer processing. There's no definition, you know, it refers to interfering with TDM without any sort of specificity about what that is. The class of literary works is very broad. It's still, although computer programs are out, it still will cover everything from like databases, which I'll talk about in a minute, to books, to poems, to, you know, journals. I mean, it's just a very broad swath of literary works. And I don't know what a database that's specifically designed for TDM, I don't know what that means. I find that, I mean, would that include Nexus? I don't know. I mean, was Nexus, Nexus has a lot of content on it. But was that content designed for TDM? I would say not. There's also concerns about what does it mean to lawfully obtain? I think you alluded to this, Reagan. You know, does that mean you can get it from someone else? Does it mean if your library has a license and you have access, say as a student at the school, that, you know, you have lawful access to it, but is that lawfully obtained? Does that mean you can make a copy of it? Even in the papers, you know, the reply comments sort of suggested that, well, maybe it wouldn't really be owned. And so that's another question. The question of who's affiliated with the institution. Could it be, you know, there are a lot of larger universities in particular of all kinds of information projects and you know, things where they have very loose affiliations with lots and lots of people. Again, I mentioned the full text access. That's a huge concern because it's very substitutional. If people can, researchers can read the books, I mean, it comes down to, you know, it's essentially a form of space shifting. And, you know, there's no protection against ultimate commercial uses, like a researcher at a university could then sell the research to, or actually be sponsored, I think, by someone for a very commercial purpose. And finally, last but not least, and I think we'll probably end up talking about this, there's a lot of issues with the security. I mean, that is, I mean, a paramount concern. You have, you know, institutions, a range of institutions, and certainly a range of users. Many of them would be individual. What does reasonable security mean? You know, it's not enough. I mean, this isn't, we're not talking about a couple DVDs here that someone's taken to because they want to create something, put it on YouTube. We're talking about potentially massive unprotected libraries. And, you know, in Hothy and Google, there were, you know, no internet facing, you know, hosting and so forth. I mean, there's, you know, there's degrees of security depending on what you have. And that's really not, it's, you know, the word, I know in some contexts, reasonable security measures may be enough to solve the problem. It has in the past, but with something like this, it really just doesn't do enough work. So that's our list of sort of concerns and at least initial concerns and reactions to even the revised proposal. Thank you for bearing with me for that list.
Okay, thank you. Mr. Williams, do you have your own list, or are there areas where you feel the requirements have satisfied the concerns?
Thank you. Yes, and we share a lot of the same concerns that Jacqueline just expressed. And I know this is about the drafting this question. We remain opposed to the need to grant this generally, but getting into the drafting, we really do appreciate the efforts made by the petitioners to narrow this down, and we acknowledge those efforts. However, there's a pretty long list of things, if I was going to go through this, that I would need to note and explain. And so 1 or 2 minutes in this context is probably not going to be enough for me to give the whole list, but I'd like to cover a few of them. One point that that Eric Stallman just made was that this goes beyond, you know, kind of academic institutions and graduate level programs. I think the record, unless I'm missing something, really is focused on faculty members and graduate students in academic institutions at the university level. And so to broaden it beyond that scope in terms of the beneficiaries of the exemption gives us pause in addition to our general opposition. If you look at the case law, as Ms. Charlesworth just said, there were very specific security measures in place, specific numbers of copies that were housed in very specific locations that were not internet accessible. There were staff members, I believe only somewhere between 6 and 10 that actually had the encryption keys in place. And so the reasonable security measures language doesn't accomplish a lot for us, because we feel it should be, if anything is drafted, much more specific, and that this is really, it seems, about almost a laboratory setting type situation for higher level academic institutions and researchers. And the copying, it's unclear who would do the circumvention exactly. Would the copies be made by a faculty member at home and then transferred to a university? Or would they be made in a more controlled setting? The databases, how many people would have access to them? Would there be no downloading capability within the databases such that only the research could be conducted without any additional copies being made? And there are additional questions that we have on the security side and the scope of the beneficiaries side. With respect to beneficiaries and those who have access, we also believe that the collaborators language and the peer review language was a helpful addition, but doesn't go far enough and isn't clear enough to really define who it is outside of each institution that may be given access to these databases and the research results. I think this is their intent, but I'm not sure that each institution's database would be limited to people affiliated with that institution specifically. And other than the collaborators and peer review individuals, this would not be a joint database shared by multiple institutions, but would be siloed institution by institution based on the copies that they have lawfully obtained. On the lawfully obtained point, I think it needs to be made clear that it is the obtained copy is a copy that essentially is a distributed copy. And I think Mr. Stallman acknowledged that in the opening. But it really should be limited to copies obtained from a licensed distribution, such as a DVD sale, or to a downloadable copy that is not a temporary copy. We wouldn't concede that such downloadable copies are owned as opposed to licensed, but I won't get into that debate now. I understand the position that they're taking on that. Ms. Charlesworth mentioned that the literary works proposal references that the TPMs must interfere with the ability to conduct text and data mining. That language is not in the motion picture drafting currently, which we would say calls into question whether alternatives such as the ones we've talked about in our comments should be taken into account before any circumvention could be engaged in. We agree with the comments a minute ago that affiliates has to be much more carefully defined. It could apply to a very, very broad group of people associated with an institution. We feel that the commercial uses are not addressed in the drafting, that while it says the beneficiaries must be nonprofit, the language doesn't actually carry over to cover whether the uses that are engaged in are commercial or not. There's no sole purpose language in there, which is common in exemptions. One question we think is worth discussing, and I know I'm going long, but there's a lot here, is, in some of the European approaches, there's a discussion of whether copyright owners should be engaged in the process cooperatively for setting security measures that would be put in place. That's not addressed here. And I think for now, I'll leave it at that. But like I said, I want to be cognizant of our time here, but this is a very, very important, big issue that the government's been studying for a long period of time without any consensus proposals. And so in this setting, without a written response to the reply comments and without opening statements, we're inherently limited in this context. So that's what I'll leave it with. I do want to reiterate, we appreciate all the efforts that the proponents made to do some narrowing, and I've talked to some of them, and I really appreciate their willingness to try to collaborate and discuss things, but we remain opposed to the exemption outright.
Okay, thank you. Mr. Moore, if you wanted to quickly outline any issues where you may either agree with the other commenters or where the refinements have iterated some of Thea's position, and then Mr. Solomon, I will let you respond.
Sure. A couple of points. I mean, one of the things that concerns us, I think, and I do want to affiliate myself with the prior remarks and will not repeat them, just emphasize a few points and hopefully add a new wrinkle or two. The first thing I want to express my agreement with is on the licensing point, in that our members license their works to institutions in the context of agreements that are negotiated, et cetera. And to the extent that those uses, particular uses, including text and data mining, are the subject of licensing restrictions or TPMs used, we would, we don't believe there's grounds for an exemption here. We do oppose it, and we do appreciate the narrowing as well. But we do think it's very important that those license terms be respected and not part of this exemption at all, should it eventually issue. The second point is that I think one should look at this type of exemption in a particular look in two contexts. Suppose a university gets a hold of a corpus of literary works, and it runs text and data mining on them. And then 3 years later, after the statute of limitations is over, it decides to make those works available to other people. That university could well be immune. And so we think it's reasonable that an additional condition, if you're going to do this, we think it ought to be limited to those institutions that do not have immunity, so that they are actually responsible for any underlying infringement that may occur. The third thing has to do with a particular fact pattern that may well elicit comments on differing views about whether it's legal or not, but it's something we're certainly concerned, and that has to do with the consumptive uses and definitional ones about what text and data mining means. Because I am not sure. I think I know what you mean, and that's something I don't want to have to explain later to my members. This is what I thought they meant. But the fact pattern that concerns me is this, which is the subject of litigation on one of our members, where a competitor took a series of copyrighted annotations, if you like, and has used those to launch a competing service. In other words, they quote unquote mined a body of copyrighted and a mix of copyrighted annotations and public domain material, and then are now using the results of that AI training to launch a competing and substitutive service. That type of activity is very concerning to us. And we do not believe that, given the steps that our members have taken to create their works and make those works available in a functioning market, that type of what we would view as market destructive behavior ought to be allowed. And based on the, based at least on the kinds of comments about looking at post-1945 novels and things like that, that doesn't appear to be, in fairness, what the intent of this exemption is. But again, I'm looking at the words that were offered. And so, you know, and part of the role here is to look for doom. And that's certainly one of the, that's one of the bad things that could happen, the way that some of this language could be read. Thank you.
Okay, thank you. I know people are looking for doom or optimism here. I think what I'm trying to do in this sort of last question before I turn it to Mr. Bell is see if there's any low-hanging fruit, and then she can sort of lead us through the orchard. So Mr. Stallman, did any of those comments, are there any other opportunities you see for compromise, such as a couple I wrote down is specifying that the uses would be non-commercial, or perhaps limiting databases so that they were not a joint efforts, unless there was, I don't know whether that would be by institution or by shared project, whether there'd be some considerations of controlled settings, such as restrictions on download of the work, or some of the users. But if you could please let me know how you would like to respond.
Yeah, so thank you. And there's a lot to respond to there, but I want to get to the points about limitations on aggregation of databases across institutions in non-commercial uses. But I think it's really important, just to respond directly to what Mr. Moore said, to clarify what the point of this exemption is, because there seems to have been some confusion about that. And I want to clarify that this exemption grew in part out of learnings from an NEH-funded Institute for Legal Literacies in Text and Data Mining. This was a convening of digital humanities scholars and copyright practitioners to really look at the work that they're doing and how it could be supported. And one thing that came across very, very clearly that there are three distinct ways that the current prohibition on circumvention in 1201 is inhibiting this work. One is it's by and large the work in digital humanities is only focusing on works in the public domain, works from 1925 and earlier, and this has the unfortunate tendency to reproduce biases in that collection, which predominantly are works written by white male authors. This both sort of marginalizes underrepresented authors, and it forecloses research into certain contemporary culturally significant phenomenon, things like the representation of Muslim Americans after the 9/11 terrorist attacks or the Harlem Renaissance. And then what is also happening is it's leading to having to do work with very limited collections. There are some cases in which there are some in copyright works available, but the value and the validity of text and data mining turns largely on the comprehensiveness of the data set. So what researchers are thinking to do is to be able to assemble their own corpora so it is sufficiently comprehensive to answer the question they seek to ask. So I understand Ms. Charlesworth's concern about the size of the data set, but this is not just sort of an unbounded data set. It's the data sets that's needed to answer the research question. And this really leads to the third problem, which is that just research projects are being abandoned entirely because there's just no way that corpora can be assembled without the researcher being exposed to significant civil and potentially criminal liability under Section 1201. So just to be perfectly clear, this is the problem we're seeking to solve, is to make it so it's the researcher's intellectual curiosity rather than the available corpora that does not require circumvention that is influencing the direction of digital humanities scholarship. So when we ask questions, things about non-commercial use, yes, we don't contemplate the work of these scholars being used for commercial purposes. So that limitation is fine. When you talk about the aggregation of data sets across institutions, the idea is the researchers themselves are assembling their own corpora to answer their own questions, not that they're reaching out to use somebody else's. And so I just want to be very clear about that, because there seems to be some sort of a conception that the exemption seeks to create this general purpose database for a host of uses. There are not things that we're contemplating. And I think the more that we think about what is the actual goal of the exemption and how that goal of the exemption both furthers the core purposes of copyright and does not really impair the normal markets for the original works, it seems like there should be room for a consensus here, and I really hope that we can get there in this hearing.
Thank you, Mr. Stallman. And I do note that Mr. Band wanted to make some comments. I'm going to jump in and move the discussion along to some more specific topics, but I promise, Mr. Band, we will get back to you and give you a chance to talk. I want to just give you a quick roadmap of where we're expecting to go in this discussion so that you have a sense of the topics that we're hoping to cover, and hopefully that will help you limit your responses to the specific topics that we're discussing and help us move the discussion along. So we're going to talk first in a little bit more detail about what text and data mining techniques really are. And I'm hoping to hear a little bit more from some of the researchers who we have on the panel today about what that would actually look like for their proposed projects, and also about some of the similarities and differences between these proposed exemptions and the EU's directive on copyright in the digital single market. Second, I would like to have a more legal discussion about whether precedent clearly establishes that text and data mining is fair use, including the scope of the Hathi Trust and the Google Books cases, the TVI's case, and then the two recent decisions we got within the past few days from the Second Circuit and the Supreme Court on fair use. I'm not going to put anybody on the spot about those specific cases, but they might inform our discussion. Third, I want to discuss specifically whether the proposed uses would be non-infringing, specifically whether they would be fair uses. And within that discussion, how and whether the works would be used for their expressive purposes, which we've already touched on a little bit, the amount of work that would be used, security issues, and the licensing market. And then finally, I know Mr. Moore discussed the contractual limits on text and data mining, and also whether there are alternatives to circumvention. So obviously that's a lot. I'll try to keep us moving at a fairly brisk pace so that we can cover those topics. As I mentioned, I would like to start out by drilling down a little bit into exactly what we mean by text and data mining techniques. The proposed exemption just uses that broad phrase. So I'm hoping to get a little more detail about what types of techniques would be used. And I understand that there's probably many types of techniques that could be possibly used, but I think it would be useful to understand. I know Dr. Baman and Dr. Wormer-Colin have specifically described some of their proposed projects, including measuring directorial style in films and conducting research on 20th century literature. So maybe they can explain, what do you mean by text and data mining within those contexts? And also, how much access would the researcher actually get to the full content of the work, whether it's a text or a motion picture? Dr. Baman.
Great, thank you for this question. So I think what I want to do is give you a sense about what my own understanding of text and data mining is definitionally, and also talk through a couple of examples, both of work that's been done and is envisioned both on the literary side and on the movie side, if that sounds okay. So the text and data mining really is about the application of a computational method in order to learn something about the data sets. Now, in the context of what we're discussing here, right, informed by discussions with humanists and social scientists, a lot of this data comes in the form of cultural objects, right? So text, movies, like these things that are the product of human creation. And in all of this work, right, however we see this kind of work being realized, an algorithm is representing this object, right? To take text as an example, in a specific way in order to make measurements about it. So earlier, I forget who mentioned this, but one example of this is to just look at the counts of words in a text, right? So how many times a given book contains the word love or hate or gun, right? For example, if we want to have a study that looks at the representation of violence in a book, having the count of the number of times we see the word gun and knife and bomb is really important to be able to do that. Now, this kind of work is often done at scale, right? So on the order of 10,000 books or 100,000 books, in order to learn about large-scale trends in culture. But at the same time, it doesn't need to be. So text and data mining can also be applied to a single work in order to trace, the illusions, for example, that it contains. Now, in terms of the work that's been done so far, right, using these kinds of methods to tell us something about culture, I've done work in the past looking at 100,000 novels published between 1800 and 2000 in order to measure how much attention characters get as a function of their gender. And what we found was something really striking, that women as authors end up giving equal attention to both male and female characters in their books, while men as authors give 3 times more attention to male characters than to female characters. So there is a very stark disparity in how gender is represented in books that has been relatively constant over the past 150 years. So that's something that we didn't know beforehand, right? That these kinds of methods really allowed us to take measurements about this phenomenon by designing algorithms that are really transforming a book into the number of characters that they have, along with the screen time that each character possesses. So in all this, we are reducing a book to a single quantity of how much attention is being given to male characters and to female characters. Other work has looked at the heteronormativity of pairings in novels, and also has found that 95% of works published in the last 70 years by major publishing houses are written by white authors, right? So really new knowledge that just didn't exist without these kind of methods that are being applied. Now, when we think about the ways that we can apply these kinds of methods to movies, there has not been a lot of work on this aspect because of these data issues that give rise to this kind of exemption that's being sought. Right? People are just not doing work in this space. And that's a huge opportunity that's being missed to tell us something about how culture is being represented in film. So the kinds of questions that we can ask if we had access to this kind of data and develop algorithms to transform movies into these kind of quantities include questions about representation again. So even just asking how much screen time women get in movies is something we can't do right now. And even if we want to have a more fine-grained notion about representation bias, to examine, for example, how Black characters are depicted in a positive or negative light, or how often they're not depicted in ways that reinforce negative stereotypes, that's again something that we could ask. We can ask questions about directorial style, right? So what is it about the films and cinematography of movies by Ava DuVernay that makes her style different from Wes Anderson, right? This is about color palettes, it's about shot type, it's about the depiction of pacing as well. Given a large enough data set, we can also ask questions about influence, right? So how often a given director influences the visual style of movies that follow, right? Stanley Kubrick is a great example of this, that Kubrick made a lot of movies that are very influential. Can we detect his signature in other movies that were produced after his own time?
So I
but
want
the most
to
important.
hang on just a moment. I want to just ask you if you could to maybe break it down in lay terms, if you can. I understand that you're talking about creating algorithms and then applying those to the works at issue. But what does that actually look like? Like, so what is the input? Is it all going through some sort of machine? And then what is the output? What does the researcher actually receive after the work is, the algorithm is run through the work, if that makes sense?
Great. Yes, absolutely. Great question. So let me talk through that. Let me talk through the tangible steps that I would go through as a researcher if I wanted to answer a question about the representation of violence in movies, for example. Right. So say that we had access to 100 years of information about movies, and we wanted to answer a question about how often we see violence being depicted in movies, right? Because people have discussed a lot about how movies are getting more violent. Maybe this is also changing the parameters of PG-13 and R, right? As the boundaries about these categories. So if I wanted to answer this question, right, and had access to movies that I could transform in order to do so, what I would do is purchase the DVDs, right? So to buy 10,000 movies in order to be able to create this kind of collection, I would run software to extract the contents of those DVDs into a digital file. I would store that data in the UC Berkeley secure computing environment, and Chris Hoffman would be able to talk about what kind of security measures are in place in this environment right now that I and my designated collaborators have access to, right? Only us. And so for this kind of question, I would design an algorithm that is specifically made to address an answer to this question. So can we measure the on-screen representation of violence in movies? So in order to do this, I would need a couple of different sources of information, right? This is a visual question, right? Because bombs explode in movies. We need to be able to detect when a bomb is going off. So we need to have access to the RGB values of the movie, right? So for every given still, these numbers that correspond to the amount of red, green, and blue in each pixel for that still. It's also expressed in dialogue, right? So, people talk in violent ways. So we would need access to the words, which come from the subtitles. And it also requires a degree of representational fidelity, right? Because we need to be able to identify a specific region of the input is a gun and not just a blob, right? So it's not something that just having a coarse grained image gets us. We need to have a high precision fidelity for all this. So get all this, what we would do is design an algorithm that would analyze the still of an image, right? Analyze the RGB values within each of those pixels to assign a numerical score to the degree of violence represented within that image. Right, we design an algorithm that measures what we're looking to measure, run that algorithm in our secure computing environment at Berkeley, where the output would be a single numerical score for every movie that we run it on. So I would put in a movie like Pulp Fiction and get out a single number like 79%, right? Where that number corresponds to the degree of violence that that movie has. The only information that we see about that movie is that single numerical score. We then publish all of that finding in a research article for everybody to see. But what we see is that single score. That would be the process.
Okay, thank you very much. And just one quick follow-up on that. If you wanted to then, using Pulp Fiction as your example, like, is there corroborating? Like, would you want to go back and look at specific scenes to corroborate that the score has captured something that is actually a gun or is actually a word that's discussing violence?
I think that would be a separate process, that in the context of running this on a really large collection of data, we would presume that there is some other kind of validation that we would have besides watching the movie and seeing if there's actually violence there. We wouldn't use the movie itself, the actual watching of it to verify that. And there's a really important reason why we can't do this, because in the context of running these algorithms on a secure computing environment or in any kind of environment that we do for our normal computation, these computers don't have screens, right? So we can't even watch the movie if we wanted to.
That's very helpful. Thank you very much. And Dr. Wormer-Cullen, would you like to provide any additional information?
Yeah, I mean, I can just try to repeat and elaborate on what David said. I think what the most important point is that TDM, text data mining, is used for the purpose of analyzing texts and movies in ways that humans cannot themselves. That means counting, features of the text or image that are way too complicated for a human to count, or to identify specific traits about them, like the color, or if something is a place name or a proper noun. These kind of large scale analyses involve way more materials than a human could read in a lifetime or watch in a lifetime, and a level of detail to what parts are analyzed far beyond what a human could do. The output that you were asking about, I think that's very important to elaborate on, is going to be, just parts from the original that will not even imitate or look like the original. So it'll be what you call extracted features or various types of computational models. And those models will contain predictions about probabilities that were learned from the original data. There's no way the original data could be reconstructed from those extracted features or models, but those models can be then analyzed by others as a way to continue doing research in the field without ever receiving access to the original material.
That's very helpful. Thank you very much. Mr. Stallman, I'm going to call on you in just a moment, but maybe when you respond, you can also answer my next question, which is the proposal states that the use would be limited to collaboration or replication and verification of research findings. But there is no limit on the time period for which the corpus can be retained. So are you imagining that it would be just for the purpose of the initial research and replication or verification of the findings within a specific time period, or could it potentially be retained indefinitely?
So thank you for the question. I just want to very quickly and very quickly just touch on the final point, just to underscore what Dr. Bannon and Dr. Verman-Colin are saying. And it's a range of techniques of computational analysis, which is, I think, in part why, if you look to, for example, the EU Digital Single Market Copyright Directive, they don't define the term. They say they refer to sort of it being in the recital that they talked about computational analysis of information in digital form, rather than trying to get overly precise with the definition. On this point of retention, the idea is that the data set would be retained for as long as is needed to validate and verify research results. And I think either Dr. Bannon or Dr. Verma-Colin are probably best able to give you a sense of how long that would be. I would say that we're concerned about having a specific time limit on the retention of the database, just because it could be that the researcher has more than one question that they want to ask. And so the idea that they would have to go and then recreate the entire database and circumvent all of those works again to basically query the same data set seems to be, one, it would lead to new acts of circumvention that seem to be unnecessary, and two, it's just not a great use of resources.
Thank you. Dr. Bannon, I'm just going to give you a quick moment to jump in and answer that retention question.
Yeah, just a very quick point here. I don't think that there are academic norms about how long data needs to be preserved within universities. But for scientific norms, reproducibility is a huge issue. I think you've probably heard about the reproducibility crisis in a number of different fields within academia. And the crux of that is being able to have data to rerun your experiments on to make sure that the results are the same as the ones you published for. So having access to data only for a very small period of time in order to carry out the initial experiment, I don't feel would be sufficient for these kinds of academic norms of reproducibility that all of us are really trying to adhere to.
Mr. Zambrano Ramos, did you have a question?
Yes, thanks, Ms. Rubel. And this is a question for the proponents. There was a mention in the record about getting an exemption to actually teach the TDM techniques themselves, so not just to do research on a body of work. So I'm curious if you could just talk a little bit more about that and why you believe that an exemption is necessary to actually teach the TDM techniques themselves. Thank you.
Mr. Stallman?
Yeah, I can take that, but then I invite any of our researchers who actually do teach these methods to chime in. The idea is specifically to teach these research methods to students in the digital humanities fields. The idea is if they can work with a corpus of works that are more relevant to them, they'll be more motivated to do this kind of research, and they'll also see it as something that's relevant to their interests. The reason why it would not be preferable to limit that kind of work to just works that are in the public domain is that students who have interest in contemporary questions of culture and language and linguistics might not see digital humanities scholarship as an attractive field to them.
Can I jump in just for one point of clarification on the retention question, Mr. Stallman? Are the academic norms that you were speaking of, are they the same in Europe as in America? Do you know?
I do not know.
Does anyone know? Because the European exception does have a limitation for the length of the research project and to verify the results. Does anyone know if it's different in Europe? Okay, Mr. Rebel.
A quick point of clarification for the proponents. The proposal for motion pictures specifies that the motion picture is lawfully made and then obtained on a DVD, etc. We were curious what the reference to the motion picture being lawfully made, what's the purpose of that phrase? Mr. Stallman?
Yeah, thank you. We actually took that language from a prior exemption. I think the concern at the time was that there would be there would be circumstances, and perhaps Mr. Williams can speak to this, in which the DVD itself had not been made lawfully, had been made by someone else and under conditions that might violate license, but the subsequent obtaining of that was not unlawful. So we just wanted to make sure this is really belt and suspenders to say that whatever concerns led to that being included in earlier exemptions dealing with works on DVDs, that we also foreclose that concern here.
Thank you, Mr. Williams.
Yes, thank you. I mean, when I saw that language, and I tried to touch on this quickly earlier, my understanding of their intent was to say really not that the motion picture was lawfully made, although that's important as well, but really that the copy of the motion picture that they are ingesting was lawfully made. So that the copy they are obtaining is not from, some peer-to-peer network or CyberLocker or some other infringing source, that they have a lawfully made disk that's in their collection that they would want to incorporate. So that was my takeaway, but I would agree with you that the word would need to be moved in the drafting to make that clear.
And just to clarify, Mr. Stallman, is that partially what you intended?
Yes.
Okay, thank you. Mr. Taylor?
I just wanted to chime in that I do think that we were more concerned at the time about physical disc piracy. So that's why it was there.
Okay, thank you. Just to touch quickly on the EU's directive. For the proponents to consider, did you consider the specific language used in Article 3 of the EU's directive? And for the opponents, is there anything that you prefer about the way that article is phrased that we might be able to borrow from to reach some sort of consensus? And I'll let Mr. Williams take that first. If he was still raising his hand, unless he was raising his hand to answer the last question.
I didn't just raise my hand, but it didn't seem to lower my hand after I just spoke. But I'm happy to address this to some extent, and I welcome others to do so too. We have looked at that language, and I did reference earlier that one thing that it seems to include is some ability for copyright owners to participate in the process of designing the security measures that would be put in place. And you've already touched on some of the other limitations that are built in there. I would caution that I don't think we should look to foreign standards that have been adopted as a be-all and end-all for our own approach, or assume that they overlap with the fair use standard or with other exceptions and limitations within our own law. Our own government, as you know, and have been involved in, has been studying these issues for quite some time without adopting the approach that Europe or Japan or others have adopted in various forms. And so I think this gets back to one of the questions you mentioned, but I don't think you've put it to us yet, so I won't go into it in detail yet. But is there really a fair use precedent? Does the precedent say this is really fair use across the board in the United States. And I don't think the precedent goes there yet. There are rather limited opinions on this issue, really, that don't, for example, cover motion pictures and don't analyze all of the specifics here, and that specifically say in some ways that that the cases are fact specific to a degree. So while it's helpful, I think, to study the other approaches in other places, and they do include some helpful limitations, I just wanted to have a cautionary note.
Thank you. Ms. Charlesworth?
Yes, no, thank you. I want to, I guess, associate myself with Mr. Williams' remarks and just emphasize the point that, you know, of course, the European approach, first of all, they're very high level principles that are meant to be then adopted more specifically. So I don't think the language is really nearly as specific as you would want here for purposes of actually regulating any conduct. But you know, the principle where even when, you know, a library is using it, or, you know, one of the accepted, you know, actors in Europe or permitted actors in Europe is using it, that the rights holders actually can, you know, apply measures, it says, to ensure the security and integrity of their networks and databases. And that's so essential here. And is actually, you know, we're not, you know, to the market issue yet, but, you know, when you look at the market that is here for TDM and some of the products, you know, that's a paramount concern. And, you know, if TDM is included in a subscription and so forth, you know, it's conducted through appropriate security. And obviously, if you know, I just want to emphasize the fact, I mean, there's a lot of references to having, say, Berkeley, you know, a large university may have secure facilities to host data, but this exemption would allow individual researchers to probably, it sounds like, collect, we're hearing examples of 100,000 books perhaps, and store them where, you know, I mean, I think that is just a really critical concern. And again, I know we haven't gotten to hop in Google, but I think we've said it enough, that really distinguishes this situation from the US precedents.
Well, let's put a pin in the idea of the rights holders potentially having a role to play in security measures. And we can come back to that idea when we specifically discuss security issues, because I think that might be an interesting point to discuss. But in the meantime, Mr. Band.
Thank you. So just a couple of points with respect to the EU directive. I note it's somewhat amusing that the rights holders are very happy to look to the EU precedent when it supports their view of the world, such as notice and stay down, for example. But when it's something that favors our view of the world, then it's not a good precedent. Second, the other point about that's worth noting with respect to the DSM with the TDM provision is that it is subject to the general provision, that the general contractual override provision, so that, you know, that to some extent responds to Mr. Moore's issues, so that even if there is a contractual restriction on doing text and data mining to something that is in a license agreement, that under the directive, the exception, the TDM exception, in essence trumps that contractual restriction. But the bigger point to recognize from all this is that all of the kinds of things that the two researchers before were talking about will be in very short order completely permissible in Europe. And it's probably already permissible in Japan. And it would be very odd if all those kinds of research activities could be done in Europe and in Japan and not in the United States. And I would think that that should just be, you know, as an initial matter, just, you know, kind of an unacceptable perspective from what we want our research activities to be, that we should be behind what is permissible in those other jurisdictions.
I
Mr.
ask
Solomon?
one, oh, I'm sorry. Could I ask one follow-up question just about the scope? So it sounded to me from Dr. Baman's description and Dr. Wormer Cullen's description that the outputs that are involved with the research you're talking about do not include expressive content. I think one of you said that it wouldn't even be possible to access portions of the films or literary works. Do I have that right? I mean, are you asking? Is the researcher describing excluding outputs that would encompass any expressive portions of the ingested works?
Dr. Baman?
I guess Dr. Baman, sorry, yeah.
So sorry, I can't speak to the legal definition of what an expressive work is, but I can say for the kind of output that I would need in order to write an academic research article to contribute some new knowledge to the world, I don't know. We absolutely don't need to have a continuous stream of a movie or a continuous quotation from a text. What we need are measurements, and those end up being reduced to single numbers.
Okay, and Dr. Wormer Cullen, is that your view also?
Yes, absolutely.
Okay, so I don't want to take up too much time, but I would like to hear, I guess, from both sides as to whether it's fruitful to consider defining text and data mining for purposes of this proposal to to exclude situations where anything other than non-copyrightable data or expressive content was somehow produced as a result or accessible as a result of the research. Mr. Stallman, I know you had your hand up before, but if you wanted to weigh in on that piece too, that would be great.
Yeah. So quickly, I just want to round out the question on the EU exception, because I don't think the question that was asked was, did we consider it when working on this proposed exemption? I just want to make clear that we did consider it. We didn't follow it for a few reasons. One is we actually went with an exemption that's slightly narrower. Because the EU exception applies to all cases of lawful access, and we wanted to avoid the sort of issues related to that. I mean, when we revised the exemption, the other issue is, and Ms. Charlesworth referred to this, is that we're still in the process of member state implementation of the exemption, and it's a little bit when you have potentially 27 variations of how this might be implemented or transposed into national law, it seemed like it might be premature to cite that as a reference. And then the third reason was the interplay between the DSM copyright directive and the Information Society directive, just because there's sort of bringing the EU version into play would potentially also require sort of study and incorporation of some parts of a completely separate EU directive. We decided it was just better to deal with a single sort of self-contained exemption. And then I just want to underscore the point that Mr. Band made, which is that it would really be an undesirable state of affairs for researchers if there were certain types of work in digital humanities that could be conducted in Europe and Japan, but not in the United States. On this question of whether or not, I just want to make sure I understand the question correctly. Is it whether or not expressive content could be copied for purposes of performing text and data mining? Because my understanding is that for this to work, the entire work must be copied.
Well, no, so I was asking about the output. So I understand that the ingestion of material into the database would involve copying the entire works, but I'm talking about what is accessible as a result of the research, as a result of the text and data mining.
Yes, and I invite Dr. Bam and Dr. Vermer-Cullen to weigh in on this, but I think better I refer to the earlier comments they're making about the extractive features of the computational analysis, which is not the expressive content.
Okay, thank you. Ms. Charlesworth?
Yes, thank you. I just wanted to, I think we've heard mainly about what would be contemplated for motion pictures. I know from the written reply comments, there's definitely suggestions of analyzing some of the expressive content, I think, directly. I found them a little confusing. So I wondered if the answer is really the same for books. And I would say, in answer to your question, specifically whether it's helpful, yes, it's certainly, I think it's helpful, although I think the other helpful piece of this is that the researchers, wouldn't have access to the full text or the expressive content directly either, which was the situation in Google and Hockey. So in other words, there's sort of two pieces to the problem. I mean, I think certainly, without, we still have a lot of other reservations, which I won't repeat, but I mean, certainly that would be very helpful to limit the access of the researchers and then also limit the output so there's no expressive content being viewed or output.
I see there's quite a few people who wanted to respond, but I'm gonna just move us along a little bit because time is passing and there's a lot of other topics that I'd like to cover. But if time permits, we can come back to this issue at the end of the rest of our discussion. So I want to pivot now to talking about whether precedent clearly establishes in the United States that text and data mining is a fair use. And I'll start us off by focusing on motion pictures. The proponents cited a number of cases in their submissions, including Google Books, HathiTrust, Kelly versus Ariba, Perfect 10, and iParadigms, but none of those cases deals with motion pictures. So for all, how are motion pictures different? Should the analysis be different for motion pictures? Mr. Taylor, were you raising your hand to respond to that question?
Yes, I can. I think that it is not a settled area of law. I mean, I think even their cases cited, Google Books clearly says that this area or activity tests the boundaries of fair use. So even in what they cite as a favorable decision, the court was very wary to say that this is non-infringing use. And I think that the problem that we have in this rulemaking in the last 20 minutes is that we don't really have an example of what this really looks like for motion pictures. And every time a proponent has come here, we've always insisted that we be able to kick the tires. And I think we just need to go back and look at the nature of this rulemaking supposed to be for non-infringing activities. All of those non-infringing activities, we have a history of educational uses. We have a history of filmmaking. So to say that we're going to create this broad new exemption without that kind of context, I think we're really getting into an area that the office has really refrained from getting into new areas of law. So that's what I would say.
Mr. Band?
So I think that you wouldn't be surprised to learn that I think that this is a very well settled area of law. And it's also not only settled in terms of the law, but in terms of the practice, right? In terms of what is going on a daily basis when you have, the text and data mining that goes on every single day of mining the internet by all kinds of companies and all kinds of, commercial entities, non-commercial entities. It's just, it's standard practice, and to suggest otherwise would be sort of like just ignoring what is going on in the world outside. So it is not only have legal decisions reached this issue, but they've also in terms of what is going on in the world, there's absolutely no doubt about it. Now, even turning specifically to motion pictures, I mean, there's no reason why the analysis should be any different with respect to a motion picture as opposed to a book or an image. Motion pictures are moving images, right? So why would that be any different? And compounding it is you might be getting to it soon, but we do have the TV Eyes case, and TV Eyes is interesting in a couple of respects. One is, the reason why that was found not to be fair use is because you could see the results, right? And the results were way too long, right? It was like these 30-minute extracts. And so, but here we're not going to have any extracts, right? You're not going to see anything. You're just going to get a number. You're not getting any images. So if anything, yes, that's a sort of a helpful precedent to us. It shows, what is clearly not fair use in this area, what would not be seen as a permitted area of text and data mining. And relatedly, it's also interesting, that Fox didn't bother appealing the district court's decision, which I forget whether it's sort of implicit or the district court actually did find the assembly of the database to be fair use. Fox didn't bother challenging that because it knew it would lose, right? So again, but it certainly was, if not explicit in the district court decision, there was certainly implicit that the assembly of the database, the taping of all of these news broadcasts was perfectly permissible.
Ms. Moore?
Thank you. I would like to just underscore the statements that Mr. Band has made. I am in agreement with those. I would also like to point out that where TVI's service made it not only possible, but a prominent feature of their database for consumers to view the clips of the audiovisual works. And as has been mentioned many times at this point, TDM research enabled by circumvention in this proposed use doesn't provide the sounds and images of the copyrighted works to the public. It was able to function as a substitute for the original works, and TDM scholarship simply is not. It also is a commercial use where here we are proposing nonprofit scholarly.
Ms. Charles-Roy?
Yes, thank you. Just from the point of view of literary works, I think one sort of a founding principle of both of Hati and Google is that the uses are non-substitutional. And I think that the problem, at least again, reading sort of through the comments and the petitioner's comments on the book side, it's really not clear, again, whether well, it seems that there would be full text access to the database. That's at least the way it's presented in the papers. And so that is substitutional if you're reviewing the expressive text. I mean, when I was in college, I read paper books and analyzed them in papers, and I bought those books, and that's certainly a use of the expression in the book. So I think that's a really fundamental question. As you know, Google spent a lot of time, Hati didn't allow full text uses for researchers, and Google actually, there was a very lengthy discussion about why the snippets were not a substitute for having the book. And so I think that's a really important concern. Also, in Google and Hati, the court basically said there was no market, at least at that time. Here you have a market. In the literary works area, we have CCC has a product to do text mining, a lot of subscriptions, particularly to scientific journals and so forth, which would all be included in this. They're part of the services that are offered are TDM services that are conducted securely and so forth. So I think, and we mentioned this in our papers. I mean, the whole, large corpora of data are becoming increasingly valuable because of AI research. So like having, there are a lot of commercial activities now going on around analyzing expressive content. And so, I really think that there's a very, as in Google, which said over and over again, and Hati, this is limited to its facts. Google said that the Google Books case said that many, many times. It was right on the cusp of fair use. It tested the boundaries of fair use. And, I think, it's very hard to talk about generalities in this area and say, oh, categorically TDM is fair use. I think that's just not a supportable position. And, you know, the office has always been very careful not to break new ground or get ahead of the law on fair use. So, you know, I think that sort of summarizes our concerns apart from the security as to why we don't think, you know, again, that the exemption is supportable on grounds of fair use.
Thank you. Mr. Stallman, maybe you can clarify for us what seems to be a factual question. Would the full text of literary works be accessible through the database for researchers?
Thank you for the opportunity to clarify this question, because I agree this seems to be tripping everyone up, and I just want to be very clear about this. The researchers themselves already have access to the book or the movie that is going to be put into the corpus for text and data mining. So it's not the case that the work is being copied so the user has access to the full expressive content, as was the concern that seemed to be that Ms. Charlesworth was. So
the answer is no.
Yeah.
Is the answer no?
Yeah. The answer is no, but to be clear, it's no because they already have that, and they don't need an exemption for circumvention to read a book or to watch a film. So just to be very clear about what this exemption is for.
Okay.
Yeah. So yeah.
No, I think we get that, but if this exemption would have a restriction and the answer is no, that seems like it is important to how the office can consider it. And I see you're saying because they don't need it, they will access, you know, the novel or whatever separately through their own purchased copies like we all did in the olden days. Thank you.
Mr. Williams?
Yes, thank you. There are distinctions between motion pictures and literary works, some of which may or may not be relevant in this context, depending on the scope that's at issue. Of course, a clip from a motion picture that's very short arguably could have more value than one sentence from a literary work, although I think one sentence from a literary work could be valuable too, because there's an established and acknowledged market for clips for motion pictures, and people want to view their favorite quick scene from a movie, and that is exploited, whereas at least according to the Second Circuit in the Google cases and HathiTrust, the snippets were not, you know, they didn't usurp a market, which one can agree with or disagree with. The TVI's case and what was said about that by Mr. Band, I don't think it's fair to presume why Fox didn't appeal an issue or didn't, whether it was decided by the district court or not. Litigators make decisions all the time, and I didn't litigate that case, but I think it would be unfair to hold it against Fox that an issue wasn't presented to the court and was never decided in the motion picture context, that issue being the creation of these full copies of motion pictures for ingestion. And that issue has just never been reached by a court, to my knowledge. And so I didn't get his words written down, so I apologize, Jonathan, if I got it wrong. But I think he said essentially that from his point of view, because of HathiTrust and Google Books, it's well established, or it's obvious that essentially all text and data mining of all different categories of works is lawful. And, you know, I would just say that after extensive multiple studies, and as recently as last year, the USPTO's report on mass digitization on AI issues says expressly that mass digitization and text and data mining as relevant examples of other activities with copyright implications may be considered copyright infringement or fair use, depending on the facts and circumstances at issue. So I don't think at least the PTO agreed that these cases by themselves establish a broad enough precedent for you to push them beyond their specific facts. And I think there's some language in the Second Circuit opinions that would also suggest that. And so, as Ms. Charlesworth said, I do think in the motion picture space, but also the literary work space, to grant this exemption, the Copyright Office would be, embracing something that is not set forth in detail in any judicial decision. And so this rulemaking essentially would potentially be articulating a government position on an issue that's been studied for a long period of time without a consensus position and without a policy proposal to Congress on this. And so our hesitancy is in large part driven by that. There is not an established precedent on this issue one way or the other.
Mr. Ban, I'll give you a chance to respond in just a moment, but I'm going to add an additional question to the pot. We did have two new decisions come down, one from the Second Circuit in the Andy Warhol Foundation case, and the other from the Supreme Court in Google versus Oracle, that both focus on fair use. So in addition to responding to the discussion relating to TBIs and the other precedent, if anybody wants to comment on whether and how those two cases may change the legal analysis, I welcome you to do so. Mr. Ban, we'll start with you.
Just first to respond to Matt's point and some of the other points, what that would suggest is that the Copyright Office could never grant an exemption based on fair use, because every fair use case by definition is limited to its facts, and so then that would basically dramatically limit the range of exemptions the office would be allowed to grant, and of course the office in the past has looked at fair use decisions as a basis for granting exemptions. And also, there is now a pretty big body of cases from multiple circuits. We're not talking about just like a district court decision here or there. We're talking about 6 or 7 circuit court decisions if you add all of the all the cases together, and that's a pretty substantial body of knowledge of cases. Also, and this is critical, and going back to Chris Moore's point of looking for doom, if someone goes beyond what is permissible by law, by fair use, then they would still be liable for an infringement action. They would still be liable for copyright infringement. Especially if somehow someone's, there was accessed content, or there was expressive content available, or somehow something was made, was distributed. I mean, all of those things would be infringements. And so the Copyright Office would simply be saying, well, we're going to allow circumvention for these kinds of activities that courts have found to be lawful. But then if somehow someone does something that seems to go beyond that, that would be still grounds for an infringement action. And even though conceivably in some circumstances damages might not be available because of sovereign immunity, they still would be injunctive relief available, et cetera. So there would be a way to sort of close that off. We're not really opening any floodgate here. And then finally, just quickly turning to the Warhol case, certainly has nothing to do with this whatsoever. I don't see how it could have any impact. Conceivably, you could look at dicta in the Google v. Oracle case, about copyright being a tax or something. But putting that aside, I don't see what that decision would really, I don't think it would have any impact on this. It's a very, very different situation. And also we're not talking about commercial actors here. We're talking about non-commercial. If we were dealing with commercial actors, then conceivably that case would have more relevance. But because we're not, I really don't see it having much relevance here.
Can I ask you a quick follow-up question, just quickly? So, I mean, I take your point about the idea that there have been a number of cases broadly involving text and data mining, HathiTrust and Google Books. But I mean, it's also true, I think, that the courts discuss the protective measures, the specific protective measures that were in place in those cases in a lot of detail, right? I mean, the court, particularly in Google Books, went on and on about how you could only, get whatever, an eighth of a page, certain pages were blacklisted. So how do we sort of deal with that, from the Copyright Office's perspective in trying to write a regulation? I mean, what you've proposed says, there need to be reasonable security measures, but that seems to be some distance away from the level of detail that, was provided in those cases. And if what we're trying to do is not break new ground, do we need to sort of adhere to some greater degree to the specific, what the court said was okay in those cases?
Well, first of all, in the Copyright Office has already decided this issue to some extent in the certainly in previous exemptions. I mean, I just think the one that comes to mind is the software preservation exemption, where there's obviously a database that's assembled, and I think that the office uses sort of like reasonable security or some language of that sort. I just don't think it's necessary, because if to go beyond that, I mean, obviously it's appropriate to talk about reasonable security, but to go into the obviously there's no reason to go into technical detail beyond that in a regulation. If a person is not applying appropriate security measures, then two things are going to happen. One, there will be they won't be adhering to the requirements of the regulation, right? If there's like a lot of leakage, they're not applying the regulation, the exemption appropriately, and they would be therefore liable for a violation of 1201. Also, they would be presumably either directly or contributorily infringing copyright, and they would be liable that way. So I just don't think it's necessary to sort of try to think of all of the worst case scenarios, because even the worst case scenario, there are legal remedies available. It's sufficient that, the protections that, the academic institutions are going to use will be sufficient to prevent those.
Mr. Hoffman, did you want to speak to security issues?
Thank you very much for that question. Yes, I do. I'm really heartened to hear this conversation about the specificity of the security controls. What are the overarching principles that should be applied for information security? And I think I can provide some perspective on how universities, including the University of California, but not just our university, are responding to this. And this is because increasingly researchers are coming to, I work kind of in an information technology space, they come to us wanting to do research on data or content that has restrictions or is secure or sensitive. Sometimes those come with very specific controls from a data provider, such as HIPAA, for instance, for protected health information. Other times it's just known that this is information that there's some risk and they require protections to be in place. So at our university, we engage in a process where we really look closely at those data. We consult with experts on campus, such as the Office of Scholarly Communications or legal counsel, to really understand kind of what are the superset of requirements and concerns and risks that might be faced bringing this kind of data into this kind of research context. Based on that, we do a security risk assessment. We identify this as high, medium, or low risk. And then if it's high risk, as this content would be, we work with the researchers to identify the appropriate environment to do their research in and develop a security plan that is shared with our information security office that really stipulates what everybody is responsible for. Because security is really you may have heard the phrase shared responsibility. We as an IT service provider, I have responsibilities, but the researcher does as well. One of the things that we do in that security plan is we have what's called a research user agreement, which the principal investigator, the main researcher, signs to say that they understand their responsibilities. They tell us when personnel on their team changes, those kinds of things. And then, we register these systems with our information security office. And I think all universities are actually given information security as a very evolving landscape. There's a lot of attention to this right now. So increasingly, our security offices are monitoring for intrusion detection, for threats, and for the kinds of activities that you don't want to have happen. So if you don't want the data to be copied out to the graduate student's computer, we can prevent that and we can monitor for it as well. So we have a number of things that we do that I see really happening at other universities as well as my own.
Do you have a sense of if these are what you just described are generally accepted understanding of what a phrase like reasonable security measures might mean, or how it would be interpreted in universities?
Yeah, and I think this is one of those, things where, each university has, set up its own process and its own procedures and policies and information systems, but they really are driven by, standards, for instance, that are provided by the federal government, by NIST, by international standards like International Standards Organization, that really, it's not just about technology. So security, all of these security frameworks come down to technical controls, administrative controls, which include like human resource policies, as well as physical controls, so that data centers have locks and have cameras that are recording what goes on in them and things like that.
And are those things happening at smaller universities and colleges as well?
Sometimes they're happening better at some of those schools. So it really does kind of depend on the local context. But I would say all universities are very concerned about information security, as well as enabling researchers to do this kind of research responsibly, right? So that we're providing the kinds of environments and clarity of kind of process and procedure, so that researchers know how to go about getting to that numeric or that finding that really is the goal of their research.
Mr. Ayers?
You may have,
sorry.
Can I just ask one question? You may have already sort of said this, but it sounds like you have not identified any particular articulation of standards or like an organizational body to work through what these measures will be. Are you aware of any in this field?
Well, okay, so actually, yes. So for instance, in our campus and actually the University of California system, based on these federal standards and these international standards, we've identified for highly sensitive data. So if we've classified this data as highly sensitive, we then have a series of kind of 17 control areas, which might include things like encryption standards that have to be in place so that the data are encrypted at rest and when they're being moved around. The standard might be more of an administrative one that says, all staff involved in a sensitive data project, in fact, all staff at our university have to do an annual cybersecurity refresher, right? So these kinds of things and sensitive systems must be registered with our information security office so that they can apply their advanced toolkits. So yes, we actually have a very specific policy that has like 34 control areas, many of them with multiple specific controls that need to be in place.
And you referenced NIST as the source of one set of standards. Is there another set of international standards created by a standards developing organization?
So the one that we use a lot of the time is information, the International Standards Organization. It's like 27001 and 27002. So we use, my job is to look at the superset of kind of requirements. So a data provider might say, like, you need to follow NIST 853, or they might say, you need to follow, HIPAA security, the HIPAA security standard, even if it's not protected health information. So we get these requirements, and really it's then a process of kind of folding them together. Sometimes we go back and say, hey, we can address the risk behind this concern in the following way. So, we do sometimes have negotiations based on what we're actually doing within our information system environment.
Thank you. Mr. Ayers?
Thank you very much. To respond both to comments by Mr. Band and Mr. Hoffman, certainly by the remedy of pursuing damages for copyright infringement would be available if movies were leaked. And that's obviously available. The problem is we want to avoid getting to that situation in the first place, especially when you consider the nature of the archives we're talking about here, where there's been discussion of, while some may be small, some may be thousands of titles. Just as we've seen in security leaks of private data in various situations, these leaks can be massive. And once the horse is out of the barn, so to speak, it's hard to put it back in. And so certainly copyright infringement damages are available. That's not the place we want to go to. We want to try to avoid that situation. And I'm encouraged to hear that the UC system thinks about data security very seriously and seems well prepared to be able to address this sort of situation. I note that while the UC system may designate this data as highly sensitive or highly confidential, there's nothing that requires anybody else to do the same, especially when the proposal as currently written deals not only with educational institutions, but deals with museums, libraries, and archives, which, archive is a potentially very broad word. Library and museum are also very broad. And those are institutions that may not have the expertise or the resources to be able to pay proper attention to the matter of security. So I would, while certainly the TPM providers in this case have continue to believe this exemption is not appropriate to pass at this time, to approve at this time in the first place, to the extent we can include more specific standards for security and clarifying the entities that are actually participating in this and eligible for the exemption would be better than not having those. So we would encourage the office to consider that.
Well, you read my mind. That's exactly what I was going to discuss next. There's a possibility that we could include language, specific language that describes, maybe something like a minimum set of security measures that could include things like encryption, authentication requirements, maybe some kind of choke that would be used to measure the rate of activity so that if there was mass downloading taking place, it would be identified and stopped. So I'm curious to hear folks' reactions to adding something like that. And also want to throw into the mix the idea that we put a pin in earlier, which is the possibility that the rights holders would participate potentially in designing the security measures. So I'm interested to hear folks' comments on any of those ideas. We'll start with Mr. Anderson.
Thank you so much. Security is really an important part of the considered use, and we want to ensure that research can take place without harming the market for the original copyrighted works. We appreciate the focus that's going on here. I'd first like to just point out like a key distinguishment from HathiTrust and Google Books that is kind of why we went with a reasonableness standard for security here. HathiTrust and Google both involved giving access to third parties to works, either through the search function or through the snippet view, and it involved millions of works, millions of copyrighted works. And while some researchers' projects may involve a lot of works, some other projects involve only a few works. So we want to make sure that we don't employ high, strict standards of security that are based off of what is reasonable for millions of works when it might not be reasonable for just a few works. And I think that gets to why we avoided putting in any specific minimum security standards. Like we agree, we think that encryption and authentication are pretty straightforward things that most researchers can engage with, but for very small research projects, such things might not even be necessary. And I think a reasonableness standard is able to encapsulate all the possible different types of research that could go on under this exemption and allows for very strict forms of security for very large databases and perhaps less strict for smaller research projects. And I'd just like to point also to something that the office has previously said in the Section 108 study document, that attempting to prescribe detailed digital security requirements tailored to each kind of use could result in an unduly burdensome requirement. And we think that the same applies here. We don't want an unduly burdensome requirement where researchers are unsure of what they're able to do for fear of running afoul of the exemption. And to answer your question about working with copyright holders in order to implement security standards, there is the fear that for, say, someone trying to create a corpus of 10,000 works, that's a lot of copyright holders that you have to track down and ask, hey, what do you want me to do with this? And they could have different standards that they want them to impose. They may not even be able to find the copyright holders. So it could be a very difficult and potentially dissuade people from even pursuing this research in the first place. So we'd probably try to stay away from a standard like that.
Thank you. Mr. Moore?
Thanks. I mean, a couple of responses on this. I mean, I think, you know, the office has a lot to consider on its plate right here. You know, one of the questions I have is how many of these considerations were fairly presented by the original petition? Because it seems to me like a number of angles were considered in terms of the language of the original petition, like security measures, but they weren't included and then they show up later. And I understand the need for give and take here, but you know, there comes a point at which there's a substantial amount of overbreadth. And it seems to me when you look at the original proposal and the additional refinements that were introduced at the reply stage and the further refinements and more detailed refinements that are introduced now, I wonder at what point what's really going on here is whether we're talking about the reply proposal, and that's actually the petition at issue here. And now we as representatives of folks who make these works available are responding in a time constrained format, and with the office operating without the benefit. Yep.
I do appreciate that, but since we're time constrained right now for this one, I do want to assure you that we'll be setting up an ex parte process and also utilizing post-hearing letters. Okay. So I think hopefully that will give someone some comfort in this. But if there's I
hear you. So on the second point, I mean, I think with respect to things like reasonable security measures, I mean, there are drafting techniques that are available, such as use of the word including. And our friends went through a number of factors, including an initial risk assessment, the development of a security plan, the implementation of a user agreement that requires a notification of change of personnel with respect to access to the corpus, consistent monitoring, and the use of some type of surveillance of data controls. I mean, these are all that is the type of specificity that in our view is appropriate to a regulatory proceeding of this nature, while at the same time, use of words like including or such as that are demonstrative that enable flexibility.
Ms. Charlesworth?
Yes, thank you. I think, first of all, you know, I've mentioned this a few times, the proposal, even the revised proposal, says that individuals can conduct this research and amass these libraries. So I think that's something that needs to be, obviously most individuals wouldn't themselves have any, you know, high security, such as what Mr. Hoffman was describing. And I appreciate his candor actually in calling this highly sensitive material, because that's exactly what it is. It's a very, especially when you get into the thousands of books or movies, it's a very, you know, that are unprotected. It is highly sensitive. And so I would say, and you know, without articulating each piece of it, really the security should be comparable to what was found acceptable, I mean, to the extent you're moving ahead with this in Google Books or Authy in terms of physical security, you know, choking, I think you mentioned that, who has actual access, who has, you know, can, in terms of staff members and so forth. And I think that's really imperative when you have a collection of this size, and that saying reasonable security, you know, again, I think I made this point earlier, if you're talking about a few CDs, that's one thing, or DVDs, but when you get into these very large collections, which are kind of the whole point of doing this sort of research, is to have a large collection that's too big to look at yourself, then you it just doesn't cut it to say reasonable measures. It needs to be more specific.
Mr. Stallman?
Great. Yeah, if I could, I would like to just briefly address the point raised by Mr. Moore, and then if I can just hand it over to Mr. Al-Ghamdi to make a point about alternatives we've been discussing. So if that's okay, the point I just want to make is this: that we acknowledge that the exemption was narrowed significantly in the reply on the reply comment, but this was an artifact of two things: one, the nature of text and data mining, and the nature of this proceeding. Text and data mining is a multi-purpose, multivalent research method that can support a number of socially beneficial uses that are also fair uses. Given that you have to propose the initial formulation of the rule before you sort of develop the factual record for it, we didn't want to bolt the door to those potential uses that were socially beneficial and fair uses that were the ones other than the uses that our core proponents sought to engage in. So then at the point at which we made our initial comment, and then we had responses to that initial comment from the opposition, and we knew at that point also the entire record of facts that would come into this proceedings. This is, again, a little bit backwards from normal notice and comment rulemaking, where you would have the record first and the rule. We try in good faith, as much as possible, to accommodate the concerns of the opponents that did not undermine the core purpose of the exemption that we were seeking. And that's really what we tried to do. And we feel like we went a long way to do that. And not all of those concessions were costless to the researchers. And we're a little bit concerned that the message would be that if you change the exemption this much, that somehow that results in a procedural footfall that undermines your core exemption, because then it sort of forces us into a position of fighting tooth and nail over issues that really aren't central to the exemption that we were seeking. So again, the narrowing of the proposed exemption in the reply comment was to do two things: one, to contour it to the factual record that was developed at that point in time, and to, as much as we can, address the concerns that were brought by opponents without undermining the core of the exemption. And that's what we really tried to do. So with that, I would like to give word to Mr. Al-Ghamdi to address the alternatives.
Okay, hang on just a second, Mr. Al-Ghamdi. We'll come to you in just a moment. Mr. Williams, did you want to jump in here?
Yes, thank you very much. And I do appreciate Mr. Stallman's efforts and the others' efforts to narrow this, although I agree with Mr. Moore's comments that it can be a frustrating process. It was helpful for them to do the narrowing, and I appreciate the time they took to do that. On the security issue and the fact that this reasonable security measures language is in other exemptions, I would reiterate that this is just a very different animal in the sense of the size of these databases potentially, and what's at issue. But also it's different in that the case law that is being relied upon here, Hathi Trust especially, goes, as Mr. Amr said, in great detail through the very specific security measures, not only just to point out that they were there, but because they were relevant to the third factor in terms of the number of people who were given access to the complete copies. It was a very controlled environment. The number was very specified by the universities. There were only 4 copies of each work made, as I understand it. Primary server copy, a secondary server copy, each at Michigan and Indiana, and then 2 backup copies that were only accessed if there was a point of failure. And different people had encryption keys to get into those copies. And even the people who maintain the system and the admins, as I read the opinion, didn't have those decryption keys. So that played a role in the third and the fourth factor in these cases. And so in most of the areas that we've dealt with in this proceeding where that language is used, there really weren't cases out there that made the security measures a part of the analysis. So that's one reason I think that if you do break new ground and recommend something here, that there should be a more specified level of security. And I did appreciate Mr. Hoffman's overview of what they do, and I think it's quite helpful. It's one reason why at the outset I said that if something is done here based on the evidence in the record and the research projects that we've been told about, I see it really as a university setting and a specific setting within a university that involves specific people in terms of the creation of the copies, the storage of the copies, accessing the copies, and how those copies are used. I don't think adopting a really broad beneficiary class would be a good idea, because it would be very difficult to know that the types of measures Mr. Hoffman's institution takes could be put in place by others. So I'll leave it with that.
Mr. Al-Ghamdi, I'm going to give you just a quick moment to respond. We are short on time at this point, and I still do want to discuss licensing and adverse effects real briefly. So Mr. Al-Ghamdi, with that in mind.
Thank you very much. That is actually the point that I wanted to talk to today, speaking about the adequacy of alternatives that exist and licensing. So thank you for the opportunity. We think and we believe that the alternatives that have been proposed by opponents in the record are not adequate for the purposes that researchers in the digital humanities interested in text and data mining need. For example, the HathiTrust Digital Library, which keeps getting brought up as a database of works that can be used. The collection of the HathiTrust Digital Library is very limited, and it does not contain the majority of contemporary literature that proponent researchers want to study, and furthermore, it does not contain any motion pictures. It's also only available to a small subset of researchers that are affiliated with member institutions. Other collections as well that have been suggested, such as Right Find for XML, they also are only focused on scientific journals and don't contain any contemporary literature that researchers need. Also, there is the issue of working across multiple siloed proprietary databases. And this is something that Dr. Wormer-Cohen actually raised in his letter attached in our initial comment about the difficulty of working with these multiple siloed databases. And this is something that perhaps he can elaborate on today. But that is another prohibitive obstacle in front of researchers. And any other suggestions and alternatives that opponents put forth, such as optical character recognition or OCR, or screen capture for motion pictures, we also find to be prohibitively time-consuming for researchers for this purpose. Finally, to the point about licensing, we haven't found any licensing model that we know of that can be used by researchers in order to license entire motion pictures for the purposes of text and data mining. We know there are models right now that exist where people can go and license short clips, for example, or still images, but no such model exists or no such pathway exists for text and data mining of entire motion pictures at this point, and opponents have not put forth an alternative for that purpose.
Mr. Ayers?
Two quick points. First, on the security question regarding not wanting to impose burdens that are perceived or requirements that are perceived as burdensome on smaller collections, I think it's important to note that it's not the quantity, perhaps it's sort of the market value. For instance, a small collection may be the most recent big blockbuster hits for whatever question is being sought to be researched. And so the exposure of that small collection could actually be very damaging to the rights holders, as opposed to a larger collection of lesser known works that are not currently popular. So I would certainly be cautious about looking at the size of the collection, especially in the context where we've learned today that these are siloed archives. And so how does the university or the other institution count the collection when there is an archive for Professor X, Professor Y, and Professor Z? Are those 3 archives? Is it 1 archive? Is it how is that counted? And in that sense, what would be reasonable security for each collection versus the 3 taken together? And further, sort of bridging over into the alternative uses, alternative measures, the concept that there may be smaller collections that the concern is, are there resources to be able to put towards appropriate security, actually may indicate that those collections are small enough that other methods for accessing the content may be useful, for instance, screen capture. And if it's a smaller project that relies on a smaller number of titles, that may be sufficient for the need at the time.
Ms. Charlesworth?
Yes, I mean, I know you're short on time, so I would refer you to our submission on these questions and just point out that, I think there's the parallel is OCR, especially for a smaller collection, which, although of course Google Books made millions of copies by OCR and they're fully searchable. So, the question is, I mean, it may take a little longer, but that's, as the office has long said, a mere inconvenience doesn't mean, you qualify for an exemption. You don't get necessarily the choice of format. So other than that, I would refer you to our submission on this issue.
Thank you. And I can assure you that we have read and will continue to look through all of the written submissions very carefully. We're close to the end of our time. I think we will just push back our discussion for a few more minutes to touch on just a couple of issues that I wanted to address that were either not teed up in the written comments or we had some questions about from the written comments. So I did want to give the opponents an opportunity to respond to proponents' argument that the existence of a potential licensing market should not be a sufficient showing of market harm. Their fear was that researchers shouldn't have to be content with using materials that are in the public domain until copyright owners decide that they want to actually create a licensing market. So I wanted to give opponents a chance to respond to that point. And we can start with Ms. Charlesworth, if your hand is raised for that purpose.
It was a leftover hand. I'm sorry.
Okay.
I'll respond very briefly again, because in the interest of time, I mean, this is something, the fair use statute says if a potential market is there, it counts against, it weighs against fair use. I think here, especially in the case of literary works, you see more than a potential market, you see an actual market. I think it's a developing market, but it's not a nothing market. And there's nothing to say that CCC can, I believe they will expand in this area. I think this is a very potentially commercially valuable market. And so I don't think that can be overlooked. I think there were a couple other examples cited in the paper of, people who are, marketing these licenses. Another thing I will point out is I do think, and I think I said this earlier, especially in the sort of journal database market, TDM is often included as part of that subscription package. And, so there's definitely quite a bit of evidence that this market exists. And as I said, I think there's no reason to think it won't continue to grow as the interest in large bodies of data, including, both nonfiction and fictional works, continues to grow for any number of reasons.
Mr. Williams?
Yes, thank you. So I appreciate the question. In this proceeding, we have to consider potential licensing markets when conducting the fair use analysis, but we also have to consider them when considering, are there alternatives to circumvention that would obviate the need for an exemption based on the language of the statute and the Section 1201 factors that lay on top of the underlying lawful use analysis. And so I think contacting copyright owners is relevant in both spaces, but I'll focus on it as an alternative. If, say, a copyright owner of a motion picture is willing to engage in licensing discussions around these issues, and a university can obtain copies without circumvention, I think that is preferable from a policy point of view to just engaging in the circumvention and assuming that there is no alternative through licensing, whether that would be charged licensing at a price, whether it would be gratis licensing with some conditions that, to get to your earlier question I failed to address, would allow the copyright owner to be involved in the security measures that are in place and specify what they would be, which I do think is worth consideration, because it would give us a record of who is using the exemption and what are they doing and what have they been willing or unwilling to do with security. That's something that we're often lacking in this proceeding with exemptions. We do get the benefit of the petitioners filing every 3 years on things, but we don't really have a record of the instances of use under each exemption. And for something as important as this, I think the idea that they would have reached out to the copyright owners to the extent they can be identified and discuss security measures with them would be a step in the right direction. It wouldn't obviate all of my concerns, of course, but I do think it would be worth consideration.
Ms. Moore?
Yes, thank you. I wanted to address the concern over harm to the developing or potential market, particularly for databases. As Google Books and HathiTrust discussed, the fact that a fair use can be licensed does not mean that those making fair uses are obligated to pay for that use. Additionally, the output for text and data mining, as we've discussed, does not function as a substitute for the original work. The fact that the works are collected into a database doesn't vitiate the conclusion that it's a fair use. Additionally, let's see, I apologize. We would like to make the point that these database markets, as noted in HathiTrust and Google Books, are making our databases of fair uses, and lost licensing revenue does not apply for those fair uses, and they don't constitute a market harm. Thank you.
Dr. Wormer-Kalan?
Yeah, I just wanted to return to the subject of siloed databases and whether they are sufficient for researchers by saying that of all the available databases do not contain sufficient amount of data and corpora for researchers to answer their questions. More importantly, what we are seeing is each individual database developing specific text data mining portals for their database. There is no way for a researcher to do a holistic analysis across different databases if separate databases contain different aspects of their corpora. Finally, those databases are producing a lot of their data through OCR, which was brought up before. It's important to point out that OCR, like other forms of screen capture, produce degraded sets of data. I have looked in a lot of detail at Gail's Scholars Lab for text data mining, as well as HathiTrust's data mining, and the OCR oftentimes is to the point of unreadability, especially when you're dealing with text in other languages. Comparing that to already born digital ebooks that could be adapted for text mining, the error rate is just too high for researchers to do the analysis.
Thank you. Let's go to Mr. Zambrano Ramos.
Yeah, just a quick question about screen capture. If the corpus of work that's necessary to do TDM is fairly small, would screen capture be an alternative to circumvention in that specific scenario? And then coupled to that, I don't know who the best party is to answer this, but I'm curious about the licensing terms that are involved in this kind of technology, and whether some of the license agreements require implementators of players, for example, operating system vendors or manufacturers, to take steps to disable screen capture. And if so, is screen capture a reasonable alternative to circumvention in those instances? Thank you.
Mr. Hoffman, did you want to address those questions?
Well, I want to actually defer that question to Dr. Bamman, but I just want to say that in my experience working with many researchers, when they have access to a reliable data repository information source to answer their questions, they will go there because they spend maybe 70% of their time creating a reasonable database or information resource for their research questions. They don't want to spend that time. So if the resource is there, they will use it. But the point is that researchers are always coming up with new questions and new methodologies and need this kind of access for uses that we cannot specify exactly right now, within secure bounds, of course, but they need that kind of access in order to address the kinds of, or develop the kinds of techniques that then vendors may build into their own offerings.
Thank you, Dr. Bamman.
Yeah, so I'd like to address the issue about screen capturing and about the licensing too. So to take the screen capturing first. Yeah, so to answer the question about whether screen capture is sufficient for smaller data sets, I would still say even in that case, it's not for two reasons. One, that with screen capture, we don't get access to really important metadata about movies. So that includes structural information like chapter boundaries, that can be useful for problems like seed and segmentation. But the biggest thing that we would need is information about the subtitles, right? So for many studies, we need to know exactly what the characters are saying in order to carry out research about them. You may be familiar with the Bechdel test as one example of this. This is a measure of gender representation in movies to see how often a movie has two women who are talking about something that is not another man in the movie, right? To answer this, we need to have access to what the words are that they're saying. So subtitles give us that. The other issue here for screen capture is really about quality. That yes, screen capture is fine for a number of research questions involving color palettes, for example, but some studies do require finer granularity. So if we want to have any kind of study that uses object recognition, right, to understand what the specific things are in the scene that we see, we need to have better granularity than just a screen capture. For example, if we want to have a question about the representation of wealth in a movie, we need to be able to find out what, not just that a car exists in the scene, but also that it's a BMW as a kind of a car. So a higher granularity really requires that. For larger movies, for larger kind of data sets that we want to create, it really is time as being the main factor why screen capture can't really work for us. And I know this suggestion was put forth in some of the responses that one of the things that we could do is just buy more computers and hire more people. But one thing I want to stress is that time is really critical here, because in the scope of this exemption, every single researcher needs to digitize their own data themselves, right? We're not talking about sharing digitized movies with each other. Every researcher needs to go through this process of digitizing their own films. And to get to this, it's important to differentiate between two different modes of computing. One of transferring the data from the physical medium, right, from the DVD onto a computer, and the other is processing that data to convert it into a specific format and then run our algorithms on our data. The bottleneck here is that first step of transferring the data from the medium onto a computer. Now, there's a number of aspects that individual researchers have control over, and funding is a part of that, right? We can get funding for buying DVDs, but one thing that is outside of any individual's control is space in a university. And having 10 computers, all with screens attached to carry out the screen capture process, requires a dedicated space and an operator to work 9 to 5 to carry out this process. That's not feasible within my university at Berkeley, or a relatively well. And if it's not possible at Berkeley, I think it's also very unlikely to be possible at other universities as well. I'd also like to address the licensing issue, if I have time for that.
Very quickly, please.
Okay, so one of the issues here with licensing is also the issue with databases and with the Hathi Trust overall. So the Hathi Trust is great for lots of questions, right? You can, but it mainly has books about literary fiction. So Virginia Woolf, William Faulkner, James Joyce. It doesn't have the kind of books that we read every day, right? The books that you buy in an airport bookstore. And if we want to carry out a study about what people are reading right now, we need to have access to that kind of books that we digitize ourselves. For licensing for movies, this is the same issue. That if we want to carry out a study that involves what people are watching right now, right, the most popular movies in the world, to see what gender is, how it's being depicted right there. Licensing is a problem because if we were to go to every single studio to license the movies that are in the top 1,000 by box office, if one studio says no, that means that completely shuts down this research. We can't carry it out if there's any single studio that doesn't allow the licensing for those terms.
Mr. Zambrano Ramos, did you have a follow-up?
Yeah, just a very good question, actually. This would probably be to AACSLA. I was specifically referring to the license terms on screen capture technology that may restrict their use on operating systems. And I was wondering if maybe opponents could speak a little bit to that, if there are licensing terms that implementers like operating system providers or manufacturers have to follow that disable screen capture. Thank you.
And a related question, and this will be the last question that I pose to the group. I think it comes back to the issue of causation. And I saw that opponents argued in the papers that even if circumvention were possible, there were still contracts and contractual provisions that may prevent the works being made for anything other than, for example, personal use. And those contractual provisions might include things like restrictions on the ability to use screen capture, or even technological restrictions on the ability to use screen capture. So perhaps these questions are related. Mr. Taylor?
Yeah, I think my colleagues will be mad if I don't raise my hand. So my understanding is that screen captures systems or programs, they don't really impose any terms of use on the users. They all basically represent that they're not circumvention devices. As we have talked on other panels, there are manufacturers who are trying to prevent the recording of DVDs on desktops and laptops. And they're variously successful for that. And that has proven a problem which has been overcome in this proceeding and on past examples. And as far as the license terms, I don't know what you're referring to, so I would refer to Mr. Williams. Maybe he has an idea.
Mr. Ayers?
Thank you. So just to address that, in the license agreements for AACS, for instance, the focus in what we call the compliance and robustness rules is on certainly on preventing the unauthorized copying and further distribution of high quality audio and video. There are some circumstances in which analog video and audio is permitted, but it's basically focusing on the high quality, high definition content. And in other contexts in these proceedings, we've not opposed the reasonable use of screen capture as a means for achieving the needs of an exemption.
Mr. Al-Ghamdi?
Thank you so much. To the point about contractual terms, nothing about additional barriers like contractual terms or browser app agreements that opponents might put up changes the fact that Section 1201's prohibition on circumvention is the cause of the adverse harm to researchers in this case. I mean, there are serious questions about the enforceability of such agreements to begin with, but in previous proceedings, the office has acknowledged these contractual terms while not weighing on their merit, and still the exemptions were passed. For example, the 2010 recommendation about allowing or circumventing computer programs on mobile devices to allow them to connect to third-party networks. Opponents raised the issue that they have contractual terms with their customers that say that customers can't circumvent these mobile devices, and the office has acknowledged that, but still mentioned that contract law is distinct from copyright law in that case. and the exemption was granted anyway.
Ms. Charlesworth?
Yeah, I mean, I think, thank you. I think this ties to sort of an issue that was raised much earlier on a couple hours ago, which is what does it mean to lawfully obtain something and own it? And versus, you know, say a subscription to a journal where you have certain privileges and uses are permitted under your license and others are not. I mean, I certainly don't, if you agree that you're not going to circumvent or conduct TDM, or perhaps maybe not conduct it independently of using the subscription providers tools for security purposes, I think that then your inability to conduct TDM is, you know, the reason for that is your contractual term. But again, I think this begs the bigger question of exactly what are we talking about here in terms of lawful access and obtaining works. I was confused. I mean, there was the initial proposal, and then the reply proposal really was for me murky in this area, and I think maybe worth some further thought and exploration if you have the opportunity.
All right, we are gonna shut this line down. I feel like the woman at the grocery store who's telling you no more people added. So we'll hear from Mr. Williams, Mr. Moore, and then Mr. Stallman will be last. Mr. Williams.
Thank you. Yes, on the question that Mr. Ramos asked about, will certain operating systems interfere with the functionality of some screen capture programs? My understanding is that might be the case on some devices with certain operating systems, but that it's certainly not true across the board, and that there are devices and operating systems out there that don't interfere with the functionality of screen capture. So historically in the proceeding, when there are alternatives of that nature, devices and platforms, operating systems that do enable the use of something, that is an alternative to circumvention. And so my understanding is screen capture would still be an alternative where it otherwise is workable. On the question of license terms, there seem to be two distinct issues. One, if I understood your question, Ms. Rubel, is do license terms prohibit the use of screen capture when you pay a copyright owner or a retailer for access or the download of the content? And I'm not personally aware of any license terms that specifically prohibit screen capture or only allow it for personal use. But it is common in the license terms to say things that, you know, you're only going to use the item for personal use and that you're not going to reproduce it or otherwise violate copyright law. But it's also common, of course, and almost across the board to say that you're not going to circumvent the TPMs that are in place. So if there was a violation of the terms of service, a breach of contract because someone used screen capture, I don't think that it would be very likely that they would not breach the same contract by circumventing the TPM. So I don't think that the end user ends up in a better place under the contractual terms to circumvent instead of using screen capture. And then finally and quickly, the other issues that was raised is, you know, this question of are copies owned versus licensed, and are the terms of service enforceable? You know, my understanding based on the reply comments and what we heard today, especially from Mr. Stallman, is that they are not looking through this exemption to include motion pictures that are available only through a subscription service or only through a time-limited download, such as a rental that's only supposed to be obtained for access for 48 hours, or a time-limited download that's only associated with a subscription that you must pay every month or else lose access to it. So that goes a long way towards resolving the delta between us on that issue of how the terms of service impact their proposal. I would still take the legal position that if someone licenses a more permanent copy of a download through an online retailer and the terms of service specify that it is a licensed copy, not an owned copy, and that, for example, if the service goes out of business, you're no longer entitled to maintain possession of that copy, that is not an owned copy, and it's a different legal matter, the analysis there. But like I said, what he's done, if I understand it correctly, does dramatically close the gap between us on that. And so even though there's a little bit of a disagreement, I think there on the law, it's smaller than it was.
Mr. Moore? You're still muted, Mr. Moore.
I'm sorry for the monologue. But the first part of my remarks were directed to Mr. Stallman, which is to say that if I suggested that anything that was submitted was done in any way other than good faith, I apologize, because that was not my intention. The second thing I would like to say is that the concerns about licensing and what in our view is the certainty of those agreements should apply also as well to those kinds of to literary works that are provided essentially as content as a service. And you will see that again in the STM context. So from our point of view, I guess we would disagree with our friend on the law. We do believe it is not, the enforceability of those agreements is not in legal doubt. I'll close. That's it. Thank you.
Thank you, Mr. Stallman. You're going to get the last word.
Wonderful, just like I drew it up. So just quickly on this point about the meaning of lawfully attained, and I really appreciate the comments of Mr. Williams, because I think we are quite close. We are trying to exclude cases of rentals or works acquired via streaming services, but with the advent of born digital works, this issue of when you actually own a copy is fraught, and we wanted to avoid the situation where someone would have an ebook that they had bought. They had downloaded and they bought a copy of it, but somehow it was viewed as not being eligible for this exemption because that purchase via a Kindle store or whatever came encumbered with some contractual restrictions. And on this point of contractual restrictions and whether or not they are the cause of the harm to the researcher or 1201, they're both potential harms to the researcher. And I just would like to refer the office to the comment filed by Kyle Courtney and Rachel Soundberg in the reply around addressing this point, because I know that was something that was raised by the publishers in their opposition. But first of all, the licensing practices for forbidding this kind of uses are not uniform across publishers, and even if they were, we still think that the 1201 is causing cognizable harm here. And then the final point is just really going to the sufficiency of the alternatives. I think that the licensing behavior with respect to these restrictions sort of points to the degree to which this is really not a space where researchers have available to them the ability through licensing channels to get copies of the works that they want to use for the digital humanities scholarship. And I think that the class of works that Mr. Bannon was talking about, contemporary popular literature, contemporary popular film, are the works we're really sort of talking about. And that no one in the course of this proceeding, when they've pointed to other databases that are available, they don't include those works, and that is precisely why the researchers have sought this exemption. And so the need for this exemption just it persists, and we remain in this state, and we will remain in the state until this exemption is granted, where the research that is being conducted using TDM in the digital humanities is being determined by the works that are available to the researcher via the public domain or a few licensing channels, rather than the works that they want to study. And just to repeat, that is the core issue that we're trying to address here.
Thank you, and thank you to everyone. I think this was a really helpful and interesting discussion. I'm gonna just pass the mic quickly to Ms. Smith.
Thank you, yes. Thank you all. Thanks for indulging us when we went a little bit over time. I wanted to talk process for a second because I do noted the concern that there might have not been an adequate opportunity to say everything that people wanted to say in response to the reply comment. So just as we'll do for the rulemaking overall, we will institute ex parte procedures to allow the office to receive additional information from parties subject to transparent guidelines. That will probably happen in a couple of weeks. We will be looking at all the proposed classes and issuing a targeted number of post-hearing letters. But I think for this class in particular, I can let you know that we do intend on letting a sort of reply type of phase. So if there are things that you want to put into writing to respond to the refinement from the reply, which again, we appreciate the spirit in which that refinement was made, you may as well get started. But we will be issuing a letter as to that. And, you know, as far as how the process happens, I think if you participated before, you realize the Copyright Office is in a tricky position where we need to do the rulemaking efficient enough so that it is beneficial, because we need to redo it every 3 years. So I know I want to thank my team, because I know they work very hard to work extremely efficiently and allow those who are participating enough time to have their say. But that's, you know, in this case, I think this has made it appropriate to have another stage, so we will be issuing a letter. So with that, we will conclude today, and then tomorrow at 10:30 Eastern, we will be entering our fourth day of hearings to evaluate proposed adjustments to the security research exemption. So thank you very much.